Hello students, I am Assistant Professor Yashun Bora from Alger School of Law, and today we'll be discussing the provisions of section 33 from section 33 to let's see where it goes. Okay. So in our earlier lecture, previous lecture, we have discussed the provisions mentioned under section 32, which again talks about four kinds of people and in the eight cases. Okay, and you must have got that particular provisions. Okay, now we'll be moving to our this lecture, and we'll be starting with the section 33. As we are discussing the relevancy of the facts, which is mentioned from section 6 to section 55. Okay, so these are the further statements or the evidences which are given by the different set of persons and the organization, and how they are relevant in the evidence act will be discussing in this particular lecture. Okay, so section 33 talks about the relevancy of certain evidence for proving in subsequent proceedings uh, the truth or fact therein stated. Now it talks about when the evidence of a witness has been taken in a judicial proceedings on or by before any person who is authorized by law to take it. Okay, now all these evidences will be relevant for the subsequent proceedings also, or in the later stages or later stage of that particular proceedings also. Okay, for example, if A is a person who has said that this land belongs to me. Okay, now in that case he brings up the evidences related to the existence of his right over that particular land. Okay, so in that case that particular evidence uh, uh, can be taken in subsequent judicial proceedings also, and it can be taken or considered in this particular in that only in that particular judicial proceedings on a later stage also. Okay, so the evidences which are given by the witnesses in a judicial proceedings on or before any person authorized to take it is relevant for the purpose of proving in a subsequent judicial proceedings or in later stage of that judicial proceedings the truth of the fact which it states when the witness is dead or cannot be found or incapable of giving evidence is kept out of the way of the adverse party, or if his presence cannot be obtained with the amount of delay or expense which under the circumstances of the case the court considered the unreasonable provided unreasonable. Okay, now you see that these particular evidences will be relevant. Okay, but in what cases it will be relevant? First, when the person is dead. Now the person is dead and he has given his evidences in you can say the earlier stage of the proceedings or in the previous proceedings. Okay, now second, when the person is cannot be found. Third, when the person uh, is kept out of the way from by the adverse party, like he is not, the adverse party is not allowing the person to come into the picture and to give the evidence. Now in that case, whatever evidence he has given in his previous proceedings or in the earlier stage of the trial or the earlier stage of the proceedings, then in that case it will be relevant. And the last thing is when the person is not like it when the person is not able to call, or you can say he cannot be obtained because of some unnecessarily delay or the amount of expenses. Suppose the person is not in the territory of India and he is outside the territory of India, then in that case that particular person cannot be called at that time, and if court calls that person, it will amount a lot of expenses to the parties and to that particular person also. Then in that case that particular evidences cannot be, like that particular evidences which is given by the person in the previous trial or in the earlier stage of trial will be relevant. Okay, now again there is a provision in that particular section. You'll see that the proceedings was between the same party or their representative in the interest. It should be between the same party itself. It should not be the different party, that A and B were the party in the earlier proceedings and now A and C are the parties, and Now A is getting out all the evidences which has been given by the person. Okay, then in that case these evidences or statement will not be relevant. So again you have to uh, take care of that particular proviso, that there should be or there must be the same parties or their representatives. Okay, it's like if the parties are not, like they are no more, then in that case their representative having the same interest in the proceedings or in the suit. Okay, then in that case the person is, like the evidences of these kind of person can be taken. Now moving further, it says that according to this section, evidence can be used in subsequent trial and the later stage of the trial. As we discussed earlier, that the evidences of this person can be considered or can be used in the subsequent trial and in the same trial or the later stage of the same trial. Again, the proviso is that the person should be, or the person must be of the same, or the parties must be same. Okay. Now moving further, that for the applicability of this section, the three conditions must be fulfilled by the person. Okay, then only this section will be applicable to him. These are: first, that the proceedings is between the same party, that we have discussed earlier, that the adverse party should have right in the first proceedings and opportunity to cross examine the witness. Okay, you have to take, like you have to take care of that particular thing, that the adverse party should have the right in the first proceedings and opportunity to cross examine the witnesses. And third, that the prosecution, that the question in issue was substantially the same in the first and second proceedings. Okay, that the question in issue must be substantially same in the first and the second proceeding. It should not be different. So again, there are same parties, and second, there is the same question is issue, or you can say same fact in issue in the second proceedings also. Now moving further in section 34, it talks about the entries in the book account regularly kept in the course of business are relevant whenever they refer to a matter into which the court has to inquire, but such statement shall not be sufficient evidence to charge any person with liability. This particular section talks about that whatever entries which have been made into the account, whether it can be included in the electing form also, it can be included in the documentary form also. Okay, during the course of the business are relevant. Okay, but again at the same time, these particular statements shall not alone be sufficient evidence to charge any person with the liability. It means that the person has to substantiate with the other evidences that yes, this particular statement is there, then only this particular statement is relevant. Now, moving further, Section 35. Section 35 again talks about the entry in any public or any other official record or register stating a fact in issue or relevant fact made by a public servant in discharge of his official duty or by any other person performance of a duty specially joined by the law of the country in which such book, register or record is kept is itself relevant. So whatever mentioned or whatever registered in a official book or a record, okay, stating that particular fact in issue, and again registered by the person or by the public servant, and he is discharging his official duty, then all these statement will be termed as a relevant statement under section 35 of Indian Evidence Act. Uh, okay, so now next, section 36. There is nothing much to uh, like discuss about these sections. They are very simple sections. You will be like able to get it in normal way. So that is the reason I'm not discussing it in a deep manner. Okay, so section 36 talks about the facts, a statement of facts in issue or relevant facts made published in map charts generally offered on for public sale, or map plans made under the authority of central government or the state government as to matter usually represented or stated in such maps chart plan themselves are a relevant fact. Now any if there is a question of any boundary related or the territorial related things, then all the uh, statements which are published in the maps or the charts, okay, which are generally for the public, in like public at large, then in that case, sorry, or the matters or all the statements or all the facts which are mentioned in those public chart or the maps will be the relevant facts under section 36. Now moving further, section 37. Now section 37 says that, now in section 37 you'll see that when the court is has to form an opinion regarding the existence of any fact which is mentioned under any law of parliament, or which is mentioned by any government under the notification, okay. Now in that case, how the court will consider the fact, if the person produces the certified copy of that particular notification or the act, uh, then in that case that particular facts will be termed as a relevant fact. Now moving further to section 38, it talks about when the court has to form an opinion as to law, any country, any statement of such law contained in a book purporting to be printed, published under the authority of government, then the court of such country contained a law contained in a book purporting will be the relevant fact, okay. Now after seeing this particular section, you must have heard about AIR, SCC, criminal law journal, labor law journal. Now all these cases in which the court has given his judgment or has settled the dispute, all these cases, if there is a question regarding to any statement, okay, then in that case court can refer the court books, all the law books which are printed out or published by the government of the country, okay, and all the statements which are mentioned in that particular law book will be the relevant fact. Now moving further, section 39. Now section 39 says that when the statement of which evidence is given form a part of a longer statement or of a conversation or part of an isolated document or contained in a document which forms a part of a book. Now you will see that these particular statements are running in a different forms. They can be into the electronic form, they can be into the documentary form, they can be into the oral form or recorded form. Then all such documents or the conversation and the statement and the book or the series or letter paper, the court considers it necessary in all the particular cases to the full understanding of the nature and effect of the statement and of the circumstances under which it was made. Now you see that there are evidences which are into different forms, and to connect all those evidences, the person has to produce the evidences. So if there is a electronic evidence, there is a documentary evidence, there is oral evidence, there are books, there are journals, there are conversation between the people, there are series of letters which is written or which has been transacted between the parties, then all those evidence the court will the court will consider it necessary in a particular case, and court will call and see the nature of the evidences, and it will be the relevant evidences under this particular circumstances. So now I presume that you have got the idea from section 33 to section 39. These are very small sections, and again not there is nothing much for them to describe or to discuss about. uh, so now I'll rest my lecture here and I'll take your leave. Till then, study hard, take care of yourself, and thank you, and see you in the next lecture.